Sexual abuse at New York City schools. Can you sue the school under the VGMVPL? Attorney Andrew M. Stengel. Sexual abuse by teachers, coaches, administrators, and other school staff is one of the most common forms of institutional sexual abuse. Also, it's one of the most underreported forms of sexual abuse. Survivors of school based abuse in New York City face unique barriers. That includes fears of not being believed and concerns about disrupting their education. Unfortunately, it also includes a sense that the institution they trusted may never be held accountable. The new section, 10-1, 104.1 provision of the New York City Victims of Gender Motivated Violence Protection Law may change that calculus entirely for survivors abused at New York City schools before January 9th, 2022. The 18-month look-back window, open through July 29th, 2027, provides a genuine opportunity to pursue civil accountability against both the individual abuser and the school itself. How schools become legally liable for employee abuse. A school or school district does not need to have directly participated in the abuse to face civil liability. Under the VGMVPL, a school can be held liable for sexual abuse. The law reaches parties who enable or direct gender-motivated violence. In the school context, this liability arises most commonly through negligent hiring. The school failed to conduct adequate background checks before hiring an individual with a history of abuse or inappropriate conduct. Negligent retention. The school received complaints, warnings, or red flags about an employee's conduct and failed to investigate or take corrective action. Negligent supervision. The school failed to implement adequate supervisory safeguards that would have detected or prevented abuse. Concealment and cover-up. School administrators knew about abuse and actively concealed it from parents, from students, from law enforcement to protect the institution's reputation. Each of these theories establishes a form of institutional enabling that falls squarely within the VGMVPL's language. A school that knew a teacher was grooming students and did nothing is not an innocent bystander. It is a participant in the harm those students suffered. Public schools versus private schools. Claims against New York City public schools involve claims against the City of New York and/or the New York City Department of Education. These claims carry certain procedural requirements. That means, under traditional notice of claim rules, there are specific filing deadlines. These deadlines differ from private litigation. The VGMVPL's new Section 10-1104.1 provision and its 18-month window are specifically designed to override prior limitations and barriers. However, the procedural landscape for municipal claims requires careful navigation by an experienced attorney. Private schools, including religious schools, charter schools, and independent schools, do not carry the same governmental procedural requirements, but may still have significant insurance coverage and institutional assets that make them viable defendants. What evidence exists in school abuse cases? One of the concerns survivors often express is that they have no documentation of the abuse. In school-based cases, there may be more evidence available than survivors realize: personnel files and employment records for the alleged abuser, prior disciplinary records or internal complaints, emails, text messages, or communications between the abuser and students, records of other students who may have reported similar conduct, records of transfers, reassignments, or sudden departures that correlate with abuse reports, third-party witnesses, other students, teachers, or parents who observed concerning behavior. An experienced attorney will issue preservation letters to the school immediately upon being retained. An attorney can prevent the destruction of potentially critical evidence. The New York City GMVA and the DOE, a history of institutional failure. New York City's public school system has faced multiple civil actions alleging that administrators failed to protect students from known predators. The new section 10-1 104.1 provision emerged in part from litigation involving abuse at city-run juvenile detention facilities. In these situations, the City of New York was on notice of abuse and failed to act. The same principles that apply to those cases apply to school-based abuse. When an institution knows or should have known about abuse and fails to prevent it, the institution bears responsibility alongside the individual abuser. What can you recover under the VGMVPL? In a successful VGMVPL lawsuit against a school for sexual abuse, survivors may recover compensatory damages for therapy and counseling costs, lost educational and career opportunities, pain and suffering, and emotional distress. There are cases when the school's conduct was particularly egregious. That includes active concealment, destruction of records, or a pattern of protecting serial abusers. In such cases, courts may also award punitive damages. Contact us now for a consultation. If you were sexually abused by a teacher, coach, administrator, or other school employee in New York City before January 9th, 2022, you may have a civil claim against both the individual and the school. The window is open through July 29th, 2027. Schedule a consultation with the law firm of Andrew M. Stengel, PC, by emailing info@stengellaw.com. For more information, please visit our website, stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.